Oftentimes when it comes to estate planning, many people think, I can put it off. It won't matter. If I pass away, my family can figure it out. However, having an estate plan in place isn't important only in death, but in life too. Estate planning is the process of anticipating and arranging for the management of a person's assets during the person's life and in preparation for their possible incapacity or death. It's an act of love. The preparation of an estate plan helps get things in order for your family, making it easier for everyone. You don't want your kids to go on a scavenger hunt after you pass and try and figure out what assets you have and where you bank, do you? When it comes to putting an estate plan in place, everyone should have the same mission. Please read this mission statement along with me. I want to control my property while I'm alive, take care of my loved ones if I become disabled, choose who takes care of me during disability, and give what I have to whom I want, when I want, and if I can, I want to save every last tax dollar, professional fee, and court costs possible. So, how do we accomplish this mission? We put an estate plan in place, which includes documents such as a last will and testament, a trust, a healthcare power of attorney, a durable power of attorney. Oftentimes people think that a last will and testament is the only document needed to get everything in order. Thanks to Hollywood, we've all envisioned the reading of a will at an attorney's office at the exclusion of certain people. However, it doesn't happen that way. While a last will and testament is an important document in the estate plan, it is only effective upon death, and it is important to note that a will must also go through the probate court, which is something you want to avoid because it's costly, time-consuming, and public. On top of that, the will only distributes assets that, number one, are not jointly held, two, do not have a beneficiary designation on them, and three, are not held in a trust. This leads us to the next document, a trust, which can be valuable during your lifetime and upon your passing. A trust is an instruction book that details who is in charge of your assets, who gets what, when, where, how, and why. And that's part of the mission. While there are many different types of trusts, a revocable living trust is the most common type that helps avoid probate, which is, as stated previously, something you want to do. Having your assets not go through probate is possible when the assets are directed to your trust. This means speaking to your bank and financial advisors to make sure that your bank accounts are retitled in the name of the trust and that the beneficiary designations on accounts are accurate. You might ask, well, can I go ahead and avoid probate by adding them to my bank accounts? Well, you can, but you really don't realize that during your lifetime, when you add your kids' names on your bank accounts, you're opening up your bank account to their creditors. So their creditors become your creditors. If you get into an automobile accident and are sued, their creditors become your creditors. Putting a trust in place, then directing your assets to that trust is the best way to avoid this. The next document that is important during your lifetime is the healthcare power of attorney. This document, you can designate a patient advocate who will make medical decisions on your behalf in the event that you cannot make them. It also includes an advance directive, meaning that you choose whether or not you have quality of life or quantity of life. According to a study done this year by the Pew Research Center, 46% of Americans who reach the age of 75 become disabled. And the thing about disability is that we don't know who this is going to touch and when it's going to touch them. So making a plan now for disability is crucial. One common misconception is that you don't need a healthcare power of attorney document if you're married. Your marriage license includes this right to make the decision for your spouse, but it's not true. While doctors would acknowledge that you are the spouse and provide information to you, legally you do not have this power to make these decisions on your spouse's behalf. So if you don't have this document in place and you need someone to make medical decisions for you, then that person would have to go through probate court and be appointed a guardian. So probate court is something you want to avoid because it's costly, public, time-consuming, which is especially an issue during an already time-sensitive and emotional period while you're receiving medical care. A healthcare power of attorney document isn't only for anticipating disability, but it's also necessary if you have a child who turns 18. Because once they're 18, you no longer have access to their medical information, and you can't make medical decisions for them if you need to. Next, we have a general durable power of attorney. Similar to designating a patient advocate in the healthcare power of attorney document, you can designate a person to manage your finances and legal matters on your behalf in the event that you can't. Now, this includes things like selling your home, hiring your CPA, and instructing financial advisors. As long as you're alive, this person can take care of these matters for you. If you don't have a general durable power of attorney document in place and end up needing someone to manage your finances for you, that person again would have to go to probate court to file for a conservatorship. This means that all of your earnings, your assets, your liabilities would be filed in court and would be public information. So avoiding a conservatorship, you can avoid this intrusion upon your financial affairs. Again, this is an important document, not only for anticipating disability, but if you have a child who's turning 18. Just like the healthcare power of attorney document, giving you the ability to access your child's medical records, you can make decisions for them if need be with the general durable power of attorney document, allowing you to handle their finances on their behalf. We've covered the basic estate planning documents: a last will and testament, a trust, a healthcare power of attorney, and a general durable power of attorney. It's time to take action and accomplish your mission. So consulting with an estate planning attorney is the best way to ensure all these documents are in place and that they accurately reflect your wishes. Email or call our office to set up a consultation today. Thank you very much for being here.
For more information, download our estate planning guide by clicking the link in the description below.